Hello, everyone. I'm delighted to see you. Just for those who are streaming us, and there are 80 of them around the country and around the world tonight, this is the largest audience we have ever had for our controversial subjects program. The church is, you never see this on a Sunday, I can promise you that. It's secularism we're celebrating tonight. I don't want to waste any more time because we have such an extraordinary topic. That's why you're here. And so I'm going to start with a little quiz. But let me first point to this slide. For 150 years, the Supreme Court did not really have a home. They had borrowed digs in the Capitol and elsewhere. And then during the New Deal, in 1932, this was begun. In 1935, it was dedicated. It's one of the most extraordinary buildings in Washington, D.C., one of the most extraordinary buildings in America. But I want you just to think about what it signifies: authority, mastery, the final arbiter. This is when the Supreme Court really got a building equal to its place in American life. I'm going to do this little quiz here. Now, you can vote more than once. How many of you think that the Supreme Court is broken? Now, I'm asking our guests to watch all this carefully.
Yeah, I love it.
How many of you think, no, it's just fine on the whole, and the grumblers are those who are unhappy with recent decisions? Okay. How many of you believe we need serious Supreme Court reform?
Oh, wow.
How many of you believe there should be term limits of some sort for justices? Holy smokes. I think we can adjourn and just send in the results here.
Fixed it.
How many of you think we should increase the number of justices?
Ooh.
The number of justices. Not so many, Elizabeth.
Yeah, I know, right?
How many of you think we need tight and enforceable codes of ethics for the justices? That's, I think, the most unanimous one so far.
You vote which one?
Yeah, both feet.
How many of you think that, at least beginning in 2000 with Bush v. Gore, that the Supreme Court is now just the third political branch of the national government? Groans. And I don't expect much on this one. But I'm going to my man Jefferson. How many of you agree with Thomas Jefferson that the Supreme Court should not have the capacity of judicial review? It should not be able to veto acts of Congress. All right. So I think you have a sense of our audience.
Yeah.
So, next slide, please. Now, I was here a couple of times ago and we had a little discussion of the future of AI. And I expressed certain skepticism about it. And then I got a subscription to ChatGPT. And now I do nothing but invent these slides. I spend 8 or 10 hours a day now sending in suggestions and then editing and so on. So I made this one. And I think you will agree that it is a pretty good sample of where the court is today. So just go back to that first slide for a minute. That's what we wanted. That's what we have. All right, next slide. All right, so I'll give you just this brief outline. We'll try to keep to it. It's going to be hard in 2 hours, but we're going to do our best. This is our roadmap. Number one, and I'm going to ask you two to comment when I finish the four. Is the court broken, and is the court system broken? Because as you know, the Supreme Court is only the highest court, then there are appeals courts and circuit courts, district courts, and so on. Number two, why did the American public become disillusioned? Number three, are Supreme Court decisions enforceable? And we're going to follow that drama here in the next couple of years, I believe.
Yes.
And number four, is reform possible? And if so, what would those reforms look like? So say a few words just to start. Elizabeth, you first.
Yeah, so first of all, I just want to thank you so much for having me here in Vail. This town is amazing. I've never been out in this part of Colorado in the summer, and it is spectacular. It is also like an absolute swamp on fire in DC right now. And I don't just mean metaphorically. So,
But you do mean metaphorically.
I mean, yeah, maybe. But so I'm very grateful to be here with my 6-year-old son. So look, I think the answers in this room are really indicative of the fact that I do think there is a problem of legitimacy. We can talk and will talk about whether it's substance, structure, both. But I think it's great we're having this conversation because a lot of these things, like, are decisions enforceable? Like 10 years ago, if you said, are we going to be talking about this? It'd be like, no, of course they're enforceable, but we got to have the conversations.
Now, were you surprised by the votes?
Not totally. I mean, look, if people are smart enough to come to this amazing event with such esteemed
Oh,
speakers,
don't flatter them.
you know, like, I feel like they're going to know that those, I was surprised more if you didn't want more justices, but maybe if you're so disillusioned, you're like, we've got enough.
Clark.
Well, I almost feel like I'm going to end up in the role of court-appointed defense counsel for the Supreme Court. So, look, it's no secret that there are problems with the Supreme Court, and we can see that from the way that votes were cast in this room. But there are problems with really all institutions in society now. I mean, the Supreme Court is still polling higher, and I think it deserves to be polling higher than Congress or the executive branch right now. So,
Or the press.
What's
Low
that?
bar.
Or the media.
That's right. That's right. So I can tell that's not a popular position, but I take my role as court-appointed defense counsel very seriously.
All right. So relatively, it's doing better than the other ones.
I think yes, and I also think that it's being asked to do things that it really wasn't designed to do. I think it's almost the equivalent of, taking your Cadillac off-roading. If you're taking that Cadillac off of jumps and running it over logs and stuff like that, it's going to exhibit some wear and tear. And I think in some ways that's what we've been doing with the Supreme Court. So to some extent, I think it's on us if the court is not working very well. We've been asking it to do things that I think it wasn't really designed to do, and it's it's showing. The stress is showing.
All right. Thank you. Next slide. All right. So is the court broken? So next slide. I just made this short list of some of the criticisms of the court. Number one, it's nakedly partisan, that it's basically a political entity now. Many decisions come out on the numbers of which president of which party appointed the justice. And that even with Gore v. Bush, it was really unsettling to see a 5-4 vote that fell out on partisan lines. Number two, it's just another political branch of government. I think many of us feel that now, or that it's at least tending that way. Number three, the ethics crisis, and of course the obvious crisis is Clarence Thomas, but not alone. But is the ethics crisis, has it eroded public support for the court? And number four, the court is out of touch with the real conditions of the American people, which goes back to term limits and so on, that these are largely older people, less old now than they have been in the past. But that are they really in touch with Rifle and Cortez and in my own state, Bowman and Richardson, North Dakota? They really know what life is like in America? They live in the bubble. And remember when Antonin Scalia was asked about this, he said, look, we travel with other elites. We hang out with other elites. We don't hang out with the people. And he would, I think, I'm sorry to say this, but I think he would regard Vail as entry-level elite. Truly. Entry-level elite. So Elizabeth, how do you take that?
Yeah, I think there is obviously a kernel of truth in every one of those critiques. I think part of it is, we're joking about the low bar on the polling, but I think we expect and want our Supreme Court to be that glorious picture, the Solomonic kind of wisdom. It is, as written in the Constitution, inherently political in the sense that the president nominates and the Senate confirms or not. So there is inherently a political partisan element. We obviously want the justices to put aside any allegiance to the person who put them on the bench, and we don't want them to follow an agenda. We want them to follow the text of the law wherever it leads, even if it is not in sync with their personal preferences. But there is going to be some political aspect to the court necessarily. And, it is a political branch of government in the sense that it is one of our political branches of government in the Constitution. And it has an interplay with the other branches. And so, as Clark was saying in the beginning, the court is being asked to do some things that it probably wasn't intended to do. some of that is because of the political balance, that legitimacy, it's trying to balance on there. If you can think it's getting off balance, a lot of it is probably because Congress is giving it a big shove, Sorry.
Oh, so you're allowed to
Yeah.
hit the moderator.
Yeah, sorry. And so, I think that is part of why the erosion of support for the court is there, because they are engaging in a lot of these decisions that are very political. I work for a nonpartisan, but definitely progressive organization. And so, my view on some of the more recent decisions, I think, is that, they further erode the public confidence in the court because they just don't match up with the way that a lot of the American people view what it means to be free and what it means to be equal and what it means to show up on the public square with equal citizenship with one another. And so, I'm talking about the Dobbs decision about striking down Roe versus Wade in particular. But I think, the going back to Citizens United, which was a ruling that, as you probably know, unleashed corporate money into the campaign process, the numbers have started to slowly go down from a very high watermark of public support. And then when you add in the substance, if you think the court isn't getting the law right, then you're going to think they're just acting for a political agenda. And particularly now that we have some things like, President Trump in his first term had, an express litmus tests of what he wanted. He wanted justices that would be willing to strike down Roe versus Wade, that would affirm gun rights, that would be on the side of business. And so, I think that lends the idea that it's even more political court than we want it to be.
Just a quick thing. Of course, Donald Trump is not alone in litmus tests.
Well, most of the time, the presidents probably had them in their head. They just never said them out loud.
Right. That's the thing.
Which is true of a lot of things for President Trump, the saying out loud part. But yes, generally they would stay away from saying a litmus test out loud.
Right. But Mrs. Clinton would not have appointed a pro-life justice. We know that.
Yeah.
Okay. So, Clark, a different kind of question, but one that we have to get on the table right away, and that is we have three branches of government, and they were meant to check and balance each other. And under the Montesquieuian theory of government, the legislative branch was to be the most powerful because it's the one that represents the people. And of the two houses, the House was to be the more important because it actually more closely represents the will of the people. The Senate is kind of at one remove. And remember, back then, senators were appointed by state legislatures. That's different now. So one of your arguments is that our system has broken down and that the legislative branch has abdicated its authority and its place in American life, and that has put pressure on every one of the branches, but particularly now on the courts.
Yeah, would you mind if I check these off real quick? Because I'm itching to say something really quickly.
But could you itch me first?
Yeah, if you insist.
Yes, please.
Yeah, I mean, so look, arguably the most important feature of our Constitution is that it constituted, meaning created out of thin air, a government that didn't exist until the Constitution was ratified, and that's the United Government of the United States, the federal government. The feature I'm referring to is the concept of enumerated federal powers, which is really just a fancy way of saying that the federal government that the Constitution creates only has a limited set of powers. Very much the same way if you hired somebody to house sit for you, you might have a list of things that it's okay for them to do, and a list, and anything that's not on that list, it's not okay for them to do. So maybe they can use the car to go to the grocery store, but they can't throw a big party, that kind of thing. That's what the Constitution properly understood provides as to the federal government. And you can read that list in maybe 30 seconds, and it's not very long. It includes things like having an army and a navy, and a system of weights and measures, and a system of post offices, and they were even so detailed as to say, oh, and also post roads. So you can do post offices and post roads. I think a big part of the problem is that the federal government now does vastly more things than the Constitution properly understood really puts on its plate. And this puts the courts in a very difficult position, because when Congress starts putting its fingers into every little part of our life, which it wasn't supposed to do, but it does, as the Supreme Court has a choice now, which is to say, okay, either we're going to go along and make sure that when the Congress is getting involved in all these aspects of people's life, that it does so according to due process and then equal protection values, et cetera, or the court says, well, you're not supposed to be doing that, whatever that is, and so we're not going along. So you could just do whatever you want over in that area. That's not very satisfying either. And so I think that the court is put in the untenable position of having to get involved in a tremendous number of disputes that if the Constitution were being both respected and implemented in the way that it was meant to, meaning a federal government of limited powers, the court just wouldn't have to be adjudicating these questions because they wouldn't come up.
Can I just summarize that in a single sentence, that the court is not alone responsible for the breakdown of our governmental system?
I think that's right.
All right, go ahead on your.
Okay, really quickly, I'm gonna follow the advice I gave my kids last week, my homeschooled kids, when they had to take their first standardized test, which is start with the easy questions and work your way up. The easiest one, of course, is number 3. Of course, the ethics crisis has eroded public support for the court. If you denied that, you probably should just excuse yourself. And even as defense counsel for the court, I'm going to admit that one. Is the court out of touch with real conditions of the United States? Yeah, to some extent, no question. They live in a bubble, and it's a lonely existence to be a Supreme Court justice or really any federal judge. You don't get to hang out with the people you used to hang out with because there's an appearance. Well, you're not supposed to. There's an appearance of impropriety hanging out with a lawyer.
Are you watching Elizabeth react?
I've been to the Federalist Society.
Yeah, I know you have. Okay, but I want to give you one illustration of how we need to be careful not to paint with too broad a brush. There was a really interesting case that came up a few years ago called U.S. v. Riley, where the question was whether the government can search your entire smartphone when you get arrested. There was already a case that says they could do that with your wallet, okay? So if I get arrested, I don't plan to, I'm a libertarian, but I'm not gonna do that stuff tonight. If I get arrested, the police can search my entire wallet without a warrant. And so when this case went up to the Supreme Court, people thought, well, the justices aren't really going to get the difference between a wallet, and a smartphone. Excuse me, that's my placard. A wallet and a smartphone. And you know what they did? They not only got it, they all got it. All 9 of them. It was a unanimous decision. And Chief Justice Roberts, was it Roberts who wrote that opinion, I think?
Yeah, well, I think they all got it because of my brief.
Okay.
So obviously I have to turn this over. But as Elizabeth helped them understand.
Yes, thank you. Yeah.
There is such a world of difference between your wallet and your smartphone. Your entire life is on that smartphone, and they got it. And people thought they wouldn't get it. Now, perhaps they wouldn't have if you hadn't filed the brief. Who knows? Okay. So to wrap up, what I would say is this: has it become just another political branch of government? No, that's not fair. That's not fair to the court. Certainly, some of the decisions are more political than others, and we'll talk about some of them here. But I just don't think that accurately describes the court as a body. It sometimes accurately describes the court in certain cases. I think we both agree that the case where it extended broad presidential immunity would be such a case, but then there are other cases where I think the court is really playing it straight. And lastly, I would say, it's easy to point a finger and say, hey, you guys are nakedly partisan, but I'll tell you what, if you were to look at the statistics, and there are people who present these, I think many of you would be very surprised at how often the court is unanimous, at how often conservative justices cross the lines to vote with liberal justices and the other way around. Guess who's got like this, lovey-dovey almost relationship? Justice Gorsuch and Justice Jackson are teaming up oftentimes in some of the most interesting criminal cases. And Justice Kagan often crosses the line to team up with the conservatives in cases involving sort of conservative values and conservative. So, for example, she took the position that I think she was alone in taking the position 10 years ago that the Constitution does not require a unanimous jury verdict in criminal cases. What an unusual position for a supposedly progressive justice to take, and she did. So it's certainly fair to say that the court is sometimes unduly partisan. I think it is unfair to say that the court is always and infallibly.
But you will acknowledge that there's widespread public perception that this is true.
Of course. And if I could get on the other side, I would like to take some bets. If I could get on the other side of that action, I'd be able to show empirically, I think, that it's not as partisan as you might.
Well, but I think just to push back on that a little bit, it's partly because pretty much the biggest decisions that come out every term are the ones that are 5-4, 6-3 now. And so I think that, a lot of people aren't paying attention to some of these ones that are more about like, the Federal Arbitration Act, although it's super important. You should pay attention to that one. But those are the cases that we're not paying attention to where it is much more likely to be unanimous. But if it's guns, abortion, religion, Trump, things like that, it's more often divided. And so that I think it's understandable that people would see it as a divided court.
I agree with that. I had one quick point. Keep in mind that ours is the shortest constitution in the world today.
About 4,200 words.
Yep, it's very short. There's not room to spell out in great detail how certain values are going to be implemented. So we definitely know how old you have to be president, because they tell us 35, right? But are you sure you know what an unreasonable search is? Because that's what the Fourth Amendment says, no unreasonable search. Are you absolutely certain that you know what due process requires in every instance? Because that's not spelled out. Do you know for sure what is a cruel or unusual punishment? These are all values that are incredibly important, but about which reasonable people can and do disagree. And I don't think it's fair to just point a finger and say partisan whenever a justice disagrees with your understanding of those terms. You're absolutely entitled to your own understanding of those terms, but in many cases, so are they.
I urge you both to watch the clock because we have a lot to get through. And I'm not attempting to be critical, just that we got a lot to get through. So let's go to the next slide. And so I hope you two just won't guffaw at this. I'm going to do a little Founding Fathers 101. So our Constitution comes from Polybius in the ancient world and Montesquieu, who wrote The Spirit of the Laws in 1743. And it had enormous influence on the Founding Fathers. And here's what they had in mind: checks and balances, separation of powers. You've all heard that. That's Civics 101. And the idea for justices of the Supreme Court is that they would be these people that are superbly well educated, nonpartisan, openly fair, rigorously committed to the Constitution, even when it doesn't square with their own opinions, that they would step back with deep, reflective maturity on every question, and they would be so well loved and respected that we would all just say, they must be right, because they have earned the right to be that definitive on these questions. Next slide. And this is sort of what we wish we had. This is my AI work again, ChatGPT, you gotta love it, right? So this is, we want someone that, above reproach and above partisanship. He wasn't actually always, but
I know, right?
But still, you know what we're saying. You want those kind of people. You want Carl Sagan to be a Supreme Court justice, and so on. So this is what we hope we get. But next slide. And here's where we are, right? Now, this is, I'm sure, Clark, you would say this is a little unfair, but these are the...
I wouldn't say it's a little unfair.
But they do show who nominates whom. Next. And here's an image. Now, with apologies to Brent Kavanaugh, he made that unfortunate beer reference in his confirmation hearings, and now here's how he will be depicted in eternity. So, next slide. Let's just look at what the Constitution says, the two of you. Article 1 is quite long. That's the legislative branch. Article 2 on the executive branch is quite long. Article 3 is very short and frustrating because it doesn't spell out much. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, meaning for life, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. So Congress can't starve them with funds. You have to keep those salaries through their term. That's more or less it. It's not all of it, but that's more or less it. And notice that it does not specify the number of justices. It doesn't specify the number of inferior court structures. It doesn't say when they have to meet and how long they have to meet. It doesn't say what cases they need to take and how. It's very vague. And so the first Congress of the United States has the Judiciary Act of 1789 to create the infrastructure of the court system. And we've made adjustments, but they basically laid down the system that we still use. The number of justices has changed over time. The original number was 6. Then when Jefferson was elected in 1800, the outgoing Federalist Congress reduced that number from 6 to 5 so that he wouldn't have the chance to name a justice. You all know FDR, who was appalled by the court's unwillingness to go along with his New Deal program, talked about a new adjustment on this. We'll come back to that later. And during the Biden administration, you heard talk of more justices and so on. But notice how vague this is. Next one. So I gave you that sort of platonic ideal of the justices, and we all know that is not what human nature permits. And James Madison, in my opinion, either the greatest of the founders or certainly one of them, the deepest thinker of the founders, along with Alexander Hamilton and John Jay, wrote the Federalist Papers, which were propaganda op-ed pieces to get people to support and ratify the Constitution. And in Federalist 51, he said what I think is one of the greatest single things ever said about America. But what is government itself, says Madison, but the greatest of all reflections on human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, or humans over humans, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. Isn't this amazing? A dependence on the people is no doubt the primary control on the government, but experience has taught mankind the necessity of auxiliary precautions. That's so good. I think this applies to 2024, 2025, as well as it has ever applied in American life. Say a little bit about this, Elizabeth.
Yeah, I mean, I think, it's really interesting to think of the space with which the Constitution, as it was first ratified and drafted, the space that it provides for the American people and their representatives to create the justice system, which is a big deal. And certainly they learned a lot from what they didn't want. They didn't want the English system where, they had the king was the law. They didn't want to have the Articles of Confederation, which were ineffective. And they wanted to have something that would truly embody the values of the Declaration of Independence. Now, as someone who was written out of a lot of the promise of the founding, I wouldn't have been able to vote. I wouldn't have been able to ratify the Constitution. I am grateful that there is a lot of vagueness and space in here, because we were able, through time and through putting flesh on the bones of the 18th century document, to write a document that we see change being written into it over the amendment process. And the arc of change, the arc of progress that we see through our amended Constitution is so deeply inspiring to me, because even James Madison, who's talking about, if men were angels, et cetera, and we can admire what he did, we've only improved upon that. Like, to be honest, I don't want 9 George Washingtons. Mm-hmm. I want a court that looks more like me, looks more like a lot of you, looks more like a lot of my community and my neighbors, preferably not enslavers either. George Washington, of course, was an amazing president, but, those are truths. And we have been through a lot in this country and made it even more what it was intended to be in the Federalist Papers, in the ideals that we are making more manifest over time than they were back then.
So I think the key takeaway there, and I think it's a wonderful insight, is that the vagueness allowed all sorts of evolution that might not have been possible without serious amendments if everything had been spelled out
Absolutely.
in deep detail. And women are one of the chief victors of that vagueness, and African Americans, Native Americans, and so on. Mm-hmm. All right, let's move on. All right, I'm just going to do one of these two, James, because we're going to run out of time here. But Jefferson was no friend of the court. He did not believe the court should have the power of judicial review. He believed that it should have the power of judicial advice. That if Congress did something that, for example, stomped on free speech, Jefferson would hope that the court would say, that does not seem to be in accord with the Constitution. So we urge you to rethink that. Go back, think harder. I think most people think that could never have worked, but that was Jefferson. And here's what he said, and I think you have to see the insights here. This is 1823, when he's just 3 years from his death. He's long gone from the presidency. At the establishment of our constitutions, the judiciary bodies were supposed to be the most helpless and harmless members. Experience, however, soon showed in what way they were to become the most dangerous, that the insufficiency of the means provided for their removal, in other words, you can't get rid of a bad justice, gave them a freehold and irresponsibility in office, that they're sort of beyond reproach. Not beyond reproach, but beyond removal. That their decisions seeming to concern individual suitors only pass silent and unheeded by the public. The public is largely indifferent. That these decisions nevertheless become law by precedent, sapping, he loves that term, sapping is undermining a building, sapping by little and little the foundations of the Constitution and working its change by construction, by metaphysical twists, before anyone has perceived that the invisible and helpless worm, I just love Jefferson. I mean, he's just so weird sometimes. The helpless worm has been busily employed in consuming its substance. In truth, man is not made to be trusted for life. No matter what justice you have, he or she is not made to be trusted for life if secured against all liability to account. You might disagree, but you see his point, right?
I do. I do see his point. I think if the Lovings were here, they would disagree. This was the couple that was only able to get married because the Supreme Court had the power of judicial review and the ability to strike down the Virginia law that prevented members of different races from getting married. So I think you're going to have problems whichever way you go. Certainly, you can have what some people refer to as judicial tyranny, but if you don't have judicial review, if you don't have a court that has the last word, you're going to have a different kind of tyranny, of the kind that many people in this country have experienced. States would just be able to continue to disregard equal protection in the 14th Amendment. 14th Amendment was added to the Constitution in 1868 in a deliberate and very conscious effort to resist efforts of Southern states to maintain newly freed African Americans in a state of constructive servitude. And it wasn't exclusively the court that finally undermined the system of Jim Crow, but they had a lot to do with it. So I would say that I always am respectful of anything that Jefferson has to say, but in this particular matter, respecting the concerns that he articulates in this passage, I still think that on balance he's mistaken, and we have been well served by a system in which we have a court that has the last word on questions like whether you can own another human being, or whether these two particular people can get married, or they can't because they happen to be members of different races or the same sex.
So Elizabeth, I've heard you talk about this, and I'm very interested in what you have to say, that, and I think everyone would benefit from this, that after the Civil War, the 13th, 14th, and 15th Amendments, ending slavery, giving black men the right to vote, and the 14th Amendment, which is now highly in the news, that this was essentially a second founding of the United States.
Absolutely. So if we think about, the Constitution as it existed in the 18th century, it, when we think about the Bill of Rights, most people know, some things about the Bill of Rights, the freedom of speech, freedom of expression, due process rights, the Second Amendment gun rights. Those only limited federal action. So states could and did trample brutally on those rights, particularly in the southern slaveholding states, where not only did they infringe the rights of enslaved people, but also abolitionists, activists who were working to end slavery. And so when we went through the Civil War, this was a question that, as Lincoln said, you couldn't be both free and slave. You had to choose. We had to make a choice as a country which direction to go in. And so that's why I really do think it was the second founding. Because first of all, we had a new birth of freedom, again in Lincoln's words, with the 13th Amendment, where we said, never again will we allow the institution of enslavement to happen in this country. And then the very important task and the very American task that was put to the Reconstruction Congress was, well, then what does it mean to be free? And the 14th and 15th Amendments really answer that. And the Reconstruction Congress went through the horrors of slavery and said, what does it mean to be unfree? And they cataloged all of the horrors and brutality of slavery, including the lack of bodily autonomy, the inability to form families, obviously the violence inflicted upon enslaved people. And they came up with the 14th Amendment, which puts into the Constitution, really for the first time, the Declaration of Independence. That is the first time that the Declaration of Independence is actually in the words of the Constitution, because it talks about equal protection, it talks about life and liberty, and the need to have due process. And so that is the first time that we have those ideals, and they apply to every governmental actor, state and federal. And so, when you think about the Constitution that we all live under today, that is really the Constitution that exists because of the second founding. The Constitution as it happened in 18th century tells, honestly, an important but only very small part of the story. The American story is so much richer when you look at the amended Constitution and the way in which generations of activists and abolitionists and everyday Americans rewrote the story of we the people and said, we are also the people, and wrote ourselves into the American story.
Just to make one historical note there, James Madison, who was the most important figure in the creation of the Constitution and who presented the Virginia Plan at the beginning of the convention in May of 1787, wanted the Constitution to already apply within the states. And Jefferson and others said, no, we want states' rights. We want the national government to do simply national things, and the states will continue to be sovereign in most respects. So that's a really interesting debate that's been going on from the very beginning. We need to move on. I'm sorry, but we will. James? I'm not going to use that. I'm not going to use that. All right, so why did the American public become disillusioned? And let's go to this next cartoon. I love this. Notice that the edifice, that beautiful, go back to number 1 just for a moment. No, the opening slide.
Oh, yeah. There are more pillars.
There's what it's supposed to look like. And then this is a recent political cartoon. I'm sorry I did not create this one myself. But you see that the edifice is crumbling, and you see what makes it really delightful is that the justices are walking off the plank, which is great. Go back now to So this is 2023, and look at this. This is, if you think the court has not lost its reputation nor part of it in American life, this is a sobering graph. In 1987, on the bicentennial of the Constitution, 76% of the American people affirmed, admired, had respect for the Supreme Court. 2024, 47%. Think of that. And this is, as you said earlier, Elizabeth, this is the one of the 3 branches of the national government that has held up really well over time. The media has been crushed. Even religion has been slipping. Certainly Congress, which is in the 20th century had very little respect by the people, the presidency. But this is the one we thought was sort of exempt from this sort of thing, and this is what's happened. So you can't deny the disillusionment. Why is the disillusionment that much?
Well, as I pointed out earlier, that graph would look a lot different if you plotted people's disillusionment with Congress
Yes.
and the president and a lot of other institutions. So let's keep it in perspective. But I think we should resist any kind of monocausal explanation here. I think that there are a variety of explanations, and I'd be very interested to hear, where Elizabeth and I maybe agree and don't agree. But I think one place we ought to look that hasn't come up yet is the confirmation process. Judge Robert Bork was nominated to the Supreme Court. I personally, as a libertarian, am so happy that he didn't get confirmed, because he took a much different view of the Constitution than I do, but that man was brilliant. He was the Solicitor General of the United States, a Yale law professor, eminently qualified to be a justice on the Supreme Court, and what Ted Kennedy did to prevent that from happening was disgraceful, just disgraceful. And that really initiated a process of personalizing the confirmation process in a way I think that that makes it almost impossible to have that much faith in the institution when you see what is done to people in the process of, not always, but oftentimes in the process of being confirmed. So the very confirmation process has been politicized. I don't think we can lay that at the feet of the court. That Congress, the Senate owns that one. But I would say that there have been a series of decisions that are very difficult to defend in terms of the outcomes. I understand a lot of people think that Bush v. Gore is such a decision. Other people think that Citizens United. I could add some of my own, obviously, as a libertarian. I think that the court in general has been too inclined to facilitate the exercise of unconstitutional government power. So I would say that some disillusionment is perfectly valid, but it also goes hand in glove with people's disillusionment in a host of other institutions that have lost our trust.
Absolutely. Elizabeth, this is not something that just happened.
Mm-hmm.
So Hugo Black was a former member of the KKK. Abe Fortas took emoluments and had to be removed, had to resign from the court. This is not the first time that there's been disillusionment, but here's my question. Is our 24/7, 365 media in which we just spend all of our time looking at these things? We used to think of them as 9 people in black robes, and now we see them as personalities. We know a lot about them. Isn't that part of the multiplier effect of disillusionment?
So I don't know. I think a little bit yes, a little bit no. I mean, first of all, they are and always have been humans. So the fact that we're seeing that, I don't think is necessarily a bad thing. And also, I might push back a little on that we know so much about them. I think, like most Americans, don't know really who's on the Supreme Court. You know, I think Scalia was like an outsized figure, so a lot of people knew who Scalia was. You know, I think a lot of the nominations that have great meaning to, you know, especially particular communities, like Justice Sotomayor, when she goes to speak, it's often like, it's like a rock star in the building. It's really exciting. You know, Justice Ketanji Brown Jackson. So I think there are a lot of faces that are some more familiar, a little more familiar now, but I don't think it's the familiarity that has bred contempt. And I think, you know, again, it's a mixture of substance and structure that I think is the problem. You know, you can chart kind of where where we started to go down. And, you know, a lot of that is around the time of Citizens United. And, you know, the interesting part, I think, as someone who spends a lot of time in the Reconstruction era, because a lot of what I do is litigating the text and history of the 14th Amendment in particular, that guarantees equal protection and due process, is that for a lot of American history, the court has been the villain of the story. You know, the kind of 1987 high point is a little bit of a historical outlier in that, you know, I think in our lifetimes, we've generally had a very positive view of the court. But that certainly was not the view of the Reconstruction Congress that drafted the post-Civil War amendments. You know, they explicitly thought that Congress would be, and, you know, granted, they were Congress people writing these amendments. Of course, they saw themselves the hero of the story, but I think they still had a point. You know, they particularly put into those amendments, which makes the 13th, 14th, and then the following amendments after different. They put in a specific enforcement power that Congress shall have the power to enforce these amendments, which we didn't see in earlier, like in the Bill of Rights, for example, because they thought that Congress would be the ones who would come in to be the heroes of our rights and our democracy and our freedoms, and they distrusted the court. And so I think we're partly seeing, you know, a more historical alignment of disillusionment with the court.
Yeah, I hold in my hands a list of really, really awful decisions of the Supreme Court over time.
Oh.
Dred Scott and moving forward. I won't read them here, but as you say, it's often been the villain, and the court after the 14th Amendment for a long time read it in the narrowest way to protect corporations, but not black men and women. So the court has not always been the exemplar of liberty and enlightenment in American life. So I think there was a high water mark in the second half of the 20th century that has now sort of drawn down. Let's go to the next slide for a minute here. I want to ask both of you about this. Sonia Sotomayor just the other day published a fiery dissent. And among other things, she said, this is not the first time the court closes its eyes to noncompliance, so that the administration's not complying. nor I fear will it be the last yet. Each time this court rewards noncompliance with discretionary relief, it further erodes respect for courts and for the rule of law. We've had a great rise in the number of dissents. I wonder what this does to the esprit de corps of this institution when different members get very bold and angry and sort of sermonize at the other justices. What does that do to the solidarity and the esprit de corps of this institution?
Well, that's a good question. I imagine only they know for sure. We can sort of hear whispers and we can make certain surmises, but I do think that my perception is that the court has become less collegial in recent years. That obviously, you had a slide earlier with the crumbling edifice of the Supreme Court, and one of the Roe leak there, that was unprecedented. The leak of a very close to final decision of that magnitude, how can that not have a real negative effect on the the relationships among justices? So, and I don't know. I mean, I respect everything that Justice Sotomayor said, in this passage, but I do think that there can be, that I hope the justices are, yeah. There's a time and a place to make a plea like that, I would say. Maybe that was the time, maybe it was the place, but I think some recognition that in some ways they're a big family, and we have to be careful how we say things to family members, even when we're right.
One more slide, and then I'm going to turn to another thing here. Today, the Supreme Court is expected to rule in the case of People versus the guy who will ignore the ruling. So I'm going to hold on this, James, with your permission. We are very, very fortunate to have a special guest. Judge J. Madison Luttig is with us. And I know we don't have much time, Judge, but I would like you to say a few words. The microphone is coming your way, and if I cut you off, it's not because I want to, but because I have to keep the clock. So please. Let's applaud this great man. We're so glad you're here. Thanks. I know you have other commitments. Thanks for coming and giving us a couple of minutes of your time. Sir.
Thank you, Clay, and thank you, Elizabeth and Neil. It's an honor for me to be here with the three of you, not vice versa, I assure you. But it's even more of an honor for me to be here with all of you. You are we the people. This government was set up so that we the people would govern ourselves. And we would govern ourselves under a rule of law. This all originated, of course, with the colonist Declaration of Independence from King George III. Fast forward 250 years, almost. Next year we'll celebrate our 250th anniversary. And for the first time in those 250 years, everything that the colonists sought their independence from the British Crown to achieve is under assault by the President of the United States of America. I just came in. I don't really know what was said in the 40 minutes before, but the topic for tonight is a Supreme Court in crisis. So most recently, I've said these things to the American people. I've said, America itself is in crisis. No one can dispute that. I said, most recently, America is in constitutional crisis. The question for tonight is the Supreme Court in crisis? No, but listen carefully. The Supreme Court has contributed mightily to both the America in crisis and, in particular, to the constitutional crisis that we face today. When I testified before Congress, the January 6th committee 3 years ago, I said, for the first time that anyone had said since the Civil War, that we would have been in a constitutional crisis had the Vice President of the United States acceded to the demands of the President of the United States that he overturn the 2020 presidential election. And I explained that to Congress. Congress asked me, well, is that, in your view, the first time that we would have ever been in constitutional crisis? And I said, yes, the first time in 250 years. Congress said, well, what about the Civil War? I said, that would be nothing compared to the crisis we would have been in had Mike Pence thrown the election to Donald Trump. And I said, for this reason. If Pence had overturned the election on January 6, 2021, there literally is no answer in the Constitution of the United States or the laws of the United States for what would come next. In short, all three branches of the United States government first could claim the right to correct it. But all three branches of the government would know that they did not actually have the right to correct it. And second, all three branches of government would not have any idea what to do. And as a practical matter, all three branches would have been paralyzed. That's what I said to Congress. Fast forward to my most recent statements about the constitutional crisis facing America. The Atlantic asked me to write a piece on Trump's first 100 days, and I was honored to do it. I did it, and I titled it, "The End of the Rule of Law in America." And chapter and verse, I analyze under the Constitution and laws every one of the president's signature initiatives during his first 100 days in office. And I concluded with citation, chapter and verse, that every single one of those initiatives, every single one of them, tariffs, deportations, all the way down the line, DOGE, every single one of them was either unconstitutional per se or otherwise in violation of the laws of the United States. And I concluded for that reason, but listen to the reason, that the President of the United States of America was knowingly, intentionally, and deliberately violating the Constitution of the United States with every single act that he took from the Oval Office. That we've never confronted anything like that. But that, my friends, is a constitutional crisis, which leads me to my final thoughts about the court. There's no question at all that the only person, entity, organization that can stop Donald Trump now is the Supreme Court of the United States. He knows that too. He's no longer worried about that. For 250 years, scholars of the Constitution have said, we will be in a constitutional crisis when and only when the President of the United States defies a Supreme Court order. I said in the Atlantic article, the President of the United States has already defied the Supreme Court order. The Supreme Court ordered him to have Embrigo Garcia facilitate his return to the United States of America, where he could have the due process that he was denied. Within a week, as you all know, the president was in the Oval Office with the dictator from El Salvador, and the two of them said to the world and to the Supreme Court, Garcia will never come back to the United States of America. And that's where that ended. And the Supreme Court couldn't do a thing about it. And they knew it. So this, in the first 100 days, the president has already defied the Supreme Court and every lower court. And he's not going to stop because he has won that war already. Today, the Washington Post called me. I was out on 95 or the highway, and they said, "If you heard that the Department of Justice has sued the federal court in Maryland," and I said, "Well, I don't even understand what you're saying." I said, let me pull over to the side of the road. And I did. And he said, "Judge, the Department of Justice has sued the individual judges, every one of them, of the federal court in Maryland." And I said, I'm sure you're right, but it's incomprehensible to me. He said, "These are the named defendants, judge by judge." And I said, "Read me the opening paragraph." He read it. And I said, "Okay." I said, "You can quote me as saying the following." And I talked to him over the phone for the next 10 minutes. This was calculated. This is part of the whole plan. Donald Trump, as of tonight, has sued, not made a filing in a pending case, sued an entire federal court of the United States of America. That's where we are. Have we reached the tipping point? We reached the tipping point 5 months ago. Thank you. You, the people, are the only ones now, not the Supreme Court. You are the only ones who can stop this now.
So Judge Luttig, would you just yield for two quick questions?
Absolutely.
Question number one. On a scale of one, question number one, you're not some flaming liberal here.
Yeah.
You're not some flaming liberal, so your concerns are deep constitutional concerns, not political concerns.
Thank you, Clay. My concerns, well, first off, I've been studying the Supreme Court, living inside that institution, and have been fast personal friends with many of the justices over the past 30 years, including this court. I am reported to have been the most conservative United States Court of Appeals judge ever to sit.
Which gives you some street cred on this subject.
Yes. Yes. Yes.
Street cred is what that gives me, yes. And
So, second question.
Yes.
You speak in grave terms here, and I think all of us are listening very carefully. On a scale of 1 to 100, if 1 means we're going to be just fine, as we always have been, and 100 is we could lose the republic, where are you tonight?
We have, as of tonight, Clay, we have lost the republic that we created after we fought the Revolutionary War to gain our independence from King George III. And that's because, as I intimated at the beginning, and I'll have more to say about this before July 4th, the 27 grievances in the Declaration of Independence by the colonists against King George and the British Crown are astonishingly identical to the grievances that America has tonight about Donald Trump. And I will have something to say about
So I just want to say this. We're so glad you're here.
Yes.
We were hoping that you could have been here for the whole evening, but we're so glad. The only thing I worry about is whether we should now cry or applaud you.
Applaud. Great to see you.
Sure. How fabulous. Oh, my goodness. Judge Luttig.
Wow.
Ah, yeah.
And I just want to put a point on what Clay just said. I appeared before Judge Luttig when I was a baby lawyer in the U.S. Court of Appeals in the Fourth Circuit, and he is deeply esteemed in the conservative legal community. You know, you might expect me to say a lot of the things that he said as a progressive, but we have common cause, a lot of us, on these rule of law questions. And the deep, deep concerns that Judge Luttig shared tonight are shared by people from across the ideological spectrum. And I would also say that Judge Luttig, and particularly his really powerful testimony before the January 6th committee, shows why it's good to sometimes see our judges outside of the hallowed marble courtrooms, because they have a lot of interesting, important things to say.
Whether you fully agree or not, and I think essentially you fully agree, I don't think we've ever had a starker moment on this stage. So one more time. All right. Shall we cheer up? Yes. So one of the questions is and he was just alluding to this.
Yes, yes.
And he said that 5 months ago, this question became moot. Are decisions enforceable? Next slide. So we all have heard the old hoary, probably apocryphal story that when the Supreme Court under Chief Justice John Marshall rebuked Georgia for trying to dispossess Native Americans, which was a federal business. Andrew Jackson, and by the way, Donald Trump's hero is Andrew Jackson, said, John Marshall has made his decision, now let him enforce it. That may not be specifically accurate, but it does encompass the point of view of Andrew Jackson. Let's watch this little video. We have a very short little video clip here for you. Walter Isaacson and Feldman of Harvard University Law. Let's watch about a minute.
That Trump reminds me of is Andrew Jackson in some ways. And of course, Andrew Jackson famously said of Chief Justice Marshall after the Supreme Court had made a decision about preventing Cherokee Indian removals, he said, well, Justice Marshall has made his decision, now let him enforce it. So what happens if the courts get defied? How do they enforce it?
I will say, like you, Walter, I was raised on that story. There's now some question about whether he actually literally said that, but the idea is consistent no matter what. And the idea is that the courts don't have a police force that works for them. They don't have an army that works for them. So in our system, the rule of law depends on the president and the executive branch actually obeying what the courts say. That's a fundamental, a foundational principle of our constitutional order. And the Jackson story is there to remind us that if a president doesn't do that, we don't have a great check.
All right, so Elizabeth, the court depends upon the public sense of its legitimacy and its finality. We have this collapse of public admiration and respect for the court. That makes it much harder for us to get behind court decisions, and I'm sure that a president who wanted to defy the court would be glad for the collapse of the court's legitimacy, because that would make it easier to justify what he was doing.
Absolutely. I mean, I think that's one of the most important points, is that the court's legitimacy is key to its being able to fulfill its role in the constitutional system.
Because it has no police force.
Right. And, although I will say, Mr. Kilmar Garcia did come back into the United States. So, there is a sense in which the court's decision worked.
Yeah.
And so I would be a little more optimistic than Judge Luttig, which I guess is not that hard, because that was pretty sobering. So maybe I'm a lot more optimistic than Judge Luttig. I think we are not quite at the point where the public would accept outright defiance of court orders. We've seen the Trump administration put a toe in the water with lower court rulings, which is still not okay. Lower courts are courts too. But I don't think that we are in a place where that would be accepted.
Could I interrupt?
Please.
Because let's say that happens, and the only other mechanism is impeachment. There has never been a successful impeachment and removal of a Supreme Court justice. There's never been a successful impeachment and removal of a president. And so the one last remedy, if a president defied the court, you're hoping the public would rise and express its deep distaste for that. I have real doubts about that, frankly.
I don't.
But you think if
I don't.
You don't.
I believe in the American people. I really do. And I'm a Southern Californian, and I see the mostly peaceful protests in Los Angeles, where people said this is not an acceptable way to treat our neighbors and fellow church members and community members, family members. This is not okay. And I think that did have some impact. And I think if there was something that was outright defiance, particularly something that strikes at our real understanding of what it means to be a democracy and to be America, I think there would be everybody in the streets.
Clark?
I'm with you, Clay. I think it really matters what the case is, and maybe
Yes.
Elizabeth's,
Yeah.
But I think if it's something that a lot of people in a certain ideological space agree with, like let's say it's an immigration-related decision, and Trump defies an order from the Supreme Court, I'm not so sure.
But see, that's what I think is what's different about this moment, is that people can disagree about immigration enforcement and like policies, priorities, that sort of thing. But what people are coming in the streets are not because they don't agree with strict immigration reform. They don't agree with this lack of due process, disappearing people from the streets.
Let me tell a very quick, but I think very encouraging story. I clerked for a federal district court judge, and he was talking to some visiting Russian judges shortly after the Soviet Union fell apart. And he told a story that left them very impressed. And the short version is that my judge was presiding over the trial of a man named Dewey Clarich, who was the #2 guy at the CIA. He was being prosecuted for lying to Congress. And at the end of trial one day, his lawyers, his defense team, said to the judge, based on what happened today, we think we're going to need to have the director of the CIA come and testify. The DOJ lawyers said, well, that's not going to be possible because he's fishing in Alaska. And the judge that I clerked for looked at them and said, if I have to send US Marshals to Alaska to put him in cuffs and bring him to my court, he'll be here. And the thing that was remarkable about it is he could have done it. That makes our system so much different than almost every other system. Now, is it still the case today? I actually think it is. I think only the president would have any chance of defying the Supreme Court, but everybody below the president, I think our system would hold firm, and judges have the power to enforce their orders. The only thing that really keeps me up at night is what happens if there's open defiance by the president of a Supreme Court decision. I think that may be coming.
So let me poll our audience here. And we're going to go to questions here, and I'm going to skip Marbury in a minute, but I want to poll you. So let's say that the court makes a ruling on some very central thing that falls under the Bill of Rights or basic American freedoms or basic American ideas of fairness. And you all get it. I mean, there's no question that this is open defiance of the court. How many of you think that of the 340 million people in this country, there would be millions of people in the street? How many of you think he'd probably get away with it? It's about even.
Mhm.
But I think Judge Luttig is telling us, in a sense, it's already happened. And bigger ones are coming. And the court is going to have to be very, very, very strategic about how it tries to check. Because just give me the Marbury just for a second. We don't have time to go through this, but in the famous early case, Marbury v. Madison in 1803, maybe the greatest Chief Justice, certainly one of them, Justice Marshall, was in a real possible head-on conflict with the Jefferson administration. And Jefferson is a formidable enemy, one of the most deeply learned men in American history. And Marshall knew that if he told Jefferson to do the thing that Marshall thought Jefferson should do, Jefferson would say, not going to do it. And maybe the court would never gain credibility again. It might permanently damage the court. So he worked in a very interesting and sly way to work around it. And he won in the long run because he installed the concept of judicial review, and that has turned out to be an extraordinarily important power. And Jefferson, although he was the cleverest person of his time, didn't even see that he had been checkmated in legacy by Chief Justice John Marshall. So you might want to just study this case a little bit over the weekend or when you go home, because it's going to be critically important to our understanding of let's just say that the court, and we can't even assume this, but let's say the court pretty unanimously believes that the president has done something that's just beyond the pale. They're going to have to be really, really careful about the way they craft that, because they want you to be on their side and they want no wiggle room, and they don't want to be defied, because if they're defied openly and the country accepts it, which I frankly think we would, Judge Luttig says that's the end of the thing. That's the end of everything right there.
Well, the good news is it's moderately easier to outwit Donald Trump than Thomas Jefferson.
We shall see, my friend. Jefferson was a better architect. Jefferson loved wine better. All right, so we're going to skip right on to is reform possible. So A, is reform possible? And B, we'll ask what is reform to look like? So you begin.
Yeah, so I think the direct answer to the question is this Congress going to pass any judicial reform? Like, absolutely not. We can barely get them to raise the debt limit and do the budget. And so I think, short term, it's not happening anytime soon. But I do think it's incredibly important to have this conversation. I think it's important to have it now. It's important to keep having it. Because as we saw when we had the slide up, a lot of the gaps are filled in by Congress when it comes to the court system, the lower courts, and in some cases, the Supreme Court. And so the number isn't set in stone. We could have more people. We could have term limits. There's nothing in the Constitution that says we can't. We could even change in some ways the cases that get to the court. And one thing that I think is really interesting, and it's generally an overlooked part of court reform history, we all think of, we might think of Jefferson or we might think of the New Deal, but one of, I think, the most relevant periods to look at for court reform is actually Reconstruction. And I will just pitch, my colleague David Gans wrote this awesome piece on court reform and Reconstruction, which is on our website, theusconstitution.org. And they did all those things. They changed the number of justices. They, for a period, limited the types of cases that the Supreme Court could hear. And one of the things that we see from that is that arguably the most impactful court reforms came not from doing those things, even though I think they're important to talk about, but through congressional enforcement legislation that laid out ways in which people could go into court and vindicate their rights. And so I would add to the conversation of court reform from the lessons of Reconstruction that we should talk about, should we add more justices? Should we add term limits? I would add to that, should we have more avenues of access to justice and ways to open the courthouse doors? And not just think about the Supreme Court, but think about, the trial court level, which is where cases start, and where, frankly, most of us, if we are ever going to encounter personally the legal system, is probably going to be there. Most of us don't end up having cases personally that go to the Supreme Court. So I would add that to the conversation. And I think it's possible. And I think a lot of the ideas are good. Partly we talked about in the beginning, the courts, one of the criticism is the court is in a bubble. I think that's a good argument for term limits. I think it's also a good argument for adding a few more justices because we have a very big, diverse country, and we should have a diversity in every sense of that word on the court as well. And just adding a few more justices makes that, frankly, more possible.
So Clark, go to the next slide just for a minute. This is fun, of course, about the sort of toothless code of ethics that Justice Roberts installed. But Clark, I think you say don't get stuck here. This is not the big thing.
Right. Well, I mean, I agree with Elizabeth. I think reform is possible. I don't know that it's probable. And I think term limits is a good one. I think there's a lot of resentment, even among people on the left, towards Ruth Bader Ginsburg for mistiming. She could have stepped down, would have given a much greater, would have been able to replace her with another Democrat-appointed justice. I think there are a couple of justices right now who might end up hanging on too long. One in particular, who has brought some opprobrium onto the court. And if this person stays on too long, I could see that catalyzing this issue. So I think that's a possibility. I'll give you a sleeper reform. We talked about enforcing court orders. That is typically done through the marshal's service. So if one of you were to defy a court order, which I strongly suggest you don't, you'll be meeting some U.S. Marshals who will be sent to arrest you and lock you up because you'll be in contempt of court. U.S. Marshals don't work for the courts. They work for the Department of Justice, and the Attorney General works for the President. There's actually a bill in Congress right now to take the Marshal Service away from the executive branch and have it be under the direct control of the judiciary. I think that's an excellent reform, and that would make it much more difficult for a president, for example, to defy the court.
Let's go to this next slide, and we're about to go to Q&A. So next one, yeah. All right, so here are a sampling of, and there have been commissions, as you know. There's been a lot of study in the last few years. You've been involved in some of these. Some of the best minds in the country have been wrestling with it. And some people say, no, I mean, don't mess with it. That's not really the issue. The issue is the American people and expectations and so on. But of the reform agenda, of the list of possible reforms, the one that comes up most often now is term limits of 18 years maybe, or a mandatory retirement at 70 or 75 or something. That one gets a lot of attention. Second, a much stronger recusal requirement. So Elizabeth, you give us Constitution 101. What is recusal and why?
Yes. So 2 and 3 are linked and are incredibly important. So generally, we don't want anyone to sit in judgment of a case in which they are personally interested. And that can include financially, relationship-wise. It's an extension of the no one should be the judge of their own case. And all the lower courts, which means the courts below the Supreme Court, they have very strict ethics codes. The Supreme Court does not have a binding ethics code. So, the trial court judge, Judge Luttig, when he was on the Fourth Circuit, they have ethics codes that are binding upon them. They have recusal requirements. The Supreme Court does not. And that should be an easy cakewalk reform to do. Like, I almost didn't even mention it because it's so obvious that we should have an ethics code. And one of the things that the term limits reform would do, because some people say, well, we can't have strict recusal requirements in the Supreme Court like we do in other courts because there's a limited number of them and we might not have enough justices to decide a case. But if we had senior justices, which is what happens on the Court of Appeals level, you have senior justices who aren't active judges, but can come and sit on cases from time to time. If you had senior Supreme Court justices who could step in when another justice is recused, that would help push back against one of those concerns.
Makes sense. Uh, an independent, nonpartisan commission to vet possible Supreme Court justice. We know a lot of them now come out of the Heritage Foundation or other foundations. And, that I think that's a sticking point for millions of Americans, that partisan entities of both sides decide who they should present to their president and to push those candidacies. And I think if we had an absolutely nonpartisan independent commission that said, we're just going to look for the most extraordinary minds in the country, and we're going to hope that they're nonpartisan, and then we'll present that list to the president. He doesn't have to follow it, or she, but that might be possible, Clark.
Yeah, no, I think that would be a great experiment to run. I don't think it's guaranteed that it would work better than the current system, but it seems unlikely to work worse. So I'd be strongly in favor of giving it a try.
So I don't know about that. And I want to get back to something you said, Clark, at the beginning about, there are broad terms in the Constitution that we have value judgments about, and that our jurists are going to have value judgments about. And that's part of where the partisan process comes in, because, through the political system that one party is going to have perhaps this certain view of equality and the other party is going to have another, or maybe even on criminal justice issues. And so when you vote for your president and you vote for your senator who are involved in that process, everyone should be thinking about the courts, which I think we're often not when we vote for our elected leaders, because they are going to be the ones who say, you are brilliant, you are qualified, and you share the value judgments that we do, and we are going to put you on the bench. And so it's kind of in the process, and I think in some ways, that part of the political process is valuable.
Real quickly, I would say this. I actually think that there is a pathology within our judiciary that is greater than any other, and we haven't talked about it yet, and that is the fact that, think of all the lawyers in the country, only a tiny, tiny percentage have ever represented the government in court, either as a prosecutor or some other courtroom advocate for government. The federal judiciary is wildly overstocked with former government lawyers, people who got their formative experience advocating for government power and prerogatives. We did a study at Cato that showed the ratio of judges who used to represent the government versus judges who used to be like Elizabeth and I, who represented people against the government, 7-1 on the federal judiciary. And it's even more pronounced on the Supreme Court. If I could change one thing about the judiciary and the Supreme Court, it would be to have near parity in the number of judges who got their formative experience representing government and the number of judges who got their experience opposing government. And we don't have that, and the courts would look radically different if we had something like that.
Totally agree.
Number 5, and this we sort of came up a little before, but an end to televised Senate confirmation hearings. You've all seen them. It's a circus.
Yep.
Pontificating senators, playing to the television cameras, playing to their base, asking disingenuous questions, trying to trip people up.
Josh Hawley.
All of the nominees are coached to say as little as possible, to be as vague as possible, and often to lie outright. And we're also looking for people without a long paper trail, because a paper trail can come back to haunt you. And the whole thing just seems to me to be one of the worst circuses in American life and unworthy of a republic. And yet there it is. Judge Bork was the first great example of that, but there's some that have been more smooth. But essentially, when that starts, I get almost nauseous to watch senators misbehave in this way.
Yes. So I have a slight amendment to that reform. So I would keep the televised confirmation hearings. I think they're really important for all of us to see. This is our Supreme Court of the United States. But I think that you can do things to the hearings to make them better. And we've seen this in some of the January 6th hearings where the members of Congress themselves did not ask the questions. And you're allowed to do, there's nothing that says that the senators themselves have to ask the questions. So they could have special counsels come in who are, frankly, more knowledgeable in the legal issues they're asking about. And that's understandable. Not every senator is going to be an expert in constitutional text and history. And so having, I think, more knowledgeable and frankly, less looking for a sound bite that they can use in their campaign ads, having that aspect of the hearings, I think would be really useful. And I do want to have one amendment to the talking about the Bork hearings. In some ways, that's kind of how it should work, in that he was honest about his views and people were horrified and he didn't get on the court.
There was more to it than that, Elizabeth.
All right, so
Yeah, but yes, but then and there have been moments on the left, for example, if you go back and look at Ruth Bader Ginsburg's confirmation hearings, she was much more forthright than recent nominees about her beliefs in the Constitution. People were not horrified, and she got on the bench.
all right, just one last thing about this. What you're suggesting, Elizabeth, is that in Senate confirmation hearings, we get the Senate out of it, the senators out of it.
So I frequently represent members of Congress, including senators, so I would never say that.
No, of course.
But we
Like,
should include more.
Could I just offer a whimsical amendment since Elizabeth got to do one? What if during this process the senators had to wear one of those electric dog shock collars? And if enough Americans push the button all at once, they get the shock.
I think the Geneva Conventions do not permit that, because some would be shocked almost out of existence. All right. We have about 80 or more people streaming this. You have here, we don't have a lot of time. Ask your questions quickly, please. Our James and Megan will try to get to you, but we want to get as many questions in as we can.
Yeah, a few other notes on that. If you're on Zoom, use the Q&A feature in your dashboard. If you're here in the room, one of us, Megan or I, will bring the microphone to you. Please speak directly into the microphone. Stand if you're able, and please find a question mark. The last thing I will say is that I brag about our community to our esteemed presenters, not only about how curious we are and how well read we are, but also about how civil we are. Please don't make me a liar. And now we can have some fun. This is honestly my favorite part of our model, is that our community actually gets to engage on these topics, especially the hard ones, with incredible resources. Thank you for being here and being willing to engage with our community. Megan's got our first question in the back.
Hello, thank you for your time tonight. I have two questions. One, what do you see about the No Kings movement that has been coming up lately? And my other question is, I'm under the impression that if we are at war, the president has the ability to suspend the Constitution. Am I right about that, or am I wrong?
No.
That was a brief answer.
That's my answer to the second question. No, not remotely. I'll leave the first one to Elizabeth.
Yeah, I mean, there were a lot of a huge grassroots national movement, the No Kings marches, demonstrations on the same day, June 14th, as the big military parade in DC. There were big things in the parade. Yes. We don't need to talk about the crowd size, but I think that it's really important that it's labeled that way, because it's something that a lot of us, many of us, hopefully most of us, can agree on, regardless of whether we disagree about some other political issues. Hopefully we can all agree that authoritarianism and the powers of a king have no place in American democracy. And so I think it's brought together a lot of people, a lot of generations who see this as existential threat to America. And I think it is. I think Judge Luttig is exactly right on that point, because whether he's right or not about whether a Supreme Court order has been violated or ignored yet, the Constitution has 100%, as he laid out, been ignored. Yes. And so the constitutional violations have already happened. Yes. We hope that the Supreme Court recognizes that they're violations, and that we hope that the administration follows the Supreme Court. But we are also holders of constitutional meaning. And so when we go out now with our feet and later with our votes, and we say this is what we see the Constitution to mean, that is an important interpretive role that we all play. And so I take a lot of inspiration and hope and frankly joy in seeing all of these members of our American community come together.
Clark, yes or no? The president can invoke the Insurrection Act,
Yeah.
the president can declare martial law.
Yep.
So he can't suspend the Constitution, but he can do a lot.
President has substantial wartime powers. They have not, I think the limits have not been tested, and I hope we don't see them tested yet.
So courts and jurists, I think throughout the world, especially in the last half century, have been under attack. Is there any example of a court successfully defying what you refer to as overt authoritarianism? I'm just thinking about courts in the Middle East. I'll take a stretch here and say, what happened in the Weimar Republic? Was there a court? Is there anything that we can look at that says, wow, those folks actually stood up?
It's a great question. I think it may be somewhat outside of my expertise. I
Yeah,
can't
no, me
speak
too.
for Elizabeth. I would say that there are not that many countries that have a genuine tradition of judicial review, in the sense that it is the perception of the public that the court not only gets the last word on contested questions of law, but that the other branches are expected to respect and obey that decision. That's a pretty unusual arrangement, and one that I think has served our country well. I don't think very many other countries in the world, whatever it says on paper, I don't think that they truly have that tradition in the way that we do.
We'll try to get to all of you.
Yes. What is, or if anything, is being done to prevent another January 6th, only this time in 2029, especially when we have a vice president who is not likely to uphold the, if President Trump were to lose the election?
Yeah, thank you for that question. I think it's really important. And, there have been some reforms in the last Congress. There were some reforms passed to try to make clearer the vice president's role, basically that he doesn't really have one. So that is much clearer in the law than it was the last time. So that is good. Whether or not there's outright defiance of the law, which, we have heard extremely disturbing remarks. The president's defenders will say they're made in jest, but, that disturbing remarks that suggest he is not interested in leaving the White House, even if the will of the American people were to show otherwise. So I think it's right to be very concerned about that. And certainly, there are efforts and have been efforts after January 6th to really focus on combating political violence. A lot of that is much more on the local level than at the federal level, but it is very much on the radar screen of a lot of the organizations that work to ensure that elections are free and fair and safe.
Could I just really quickly say, the reform to which Elizabeth referred a moment ago was a rewriting of something called the Electoral Count Act, which is a really badly written law. It's better now. I just want to brag on two of my colleagues, Wally Olson and Tommy Berry. They were intimately involved in working with members of Congress to reform that particular piece of legislation. It is better now. And so at least some of the confusion that occurred on January 6th will, I don't know what kind of confusion will occur in 2029, but it won't be that particular kind of confusion, because to some extent, we fixed that part of the problem.
I just want to riff for 1 second on what Judge Luttig said. For me, when I'm haunted by January 6th, I think of what would have happened if Vice President Vance had gotten into that Secret Service limo. And I think that our republic pivoted on that moment alone. And he wisely said, I'm not getting in the limo, because if he had it is not clear to me that he would have come back to Congress that day.
Oh.
Next question. Yeah.
Given the changes in the country from 1776 to now, in every way possible, given even in our place in the world and the makeup of our citizenry, how important is it when future presidents consider future people for the Supreme Court, whether they're originalists or whatever the other one is?
We haven't talked about theory.
Yes. So I got to say, I love that question, because as a progressive litigator, originalism is generally thought of as a conservative methodology. And one of the unique things about my organization is that we are, for lack of a better term, you said, or the other thing, that is the problem. I'd love, if anyone has an idea for the other thing that like fits on a bumper sticker, like originalism, please let me know, because some people will say, like I often say constitutional text and history, that does not fit on a bumper sticker. But we at my organization kind of do what, for lack of a better term, is called progressive originalism, which means that we also take the Constitution's text and history, but we use it to advocate for generally different outcomes than conservative originalists. And part of the way we do that is we look at the whole Constitution instead of the Constitution as it existed in 1789. We take very seriously the ways in which the second founding after the Civil War, the progressive era amendments that gave women the right to vote, that made democracy more direct, that prevented a poll tax, that gave the right to vote to younger people. These amendments that, when we look at constitutional text and history, make our Constitution more equal, more just, more inclusive, and to my mind, more of the Constitution that we thought we would have in the ideals of the Declaration of Independence. So I would say, I think that all presidents across the ideological spectrum should look for jurists who focus on the text and history of the Constitution, because it is their job to interpret and apply the law. And that doesn't mean that you're going to be conservative or progressive. I mean, I would say if you're giving an accurate reading of the whole Constitution, it leads to mostly progressive outcomes, but that's my, position of advocacy. So I would say that, everyone should be looking for jurists. And Justice Ketanji Brown Jackson is a great example of that. When she was in her confirmation hearings, she said that the way she described her process, looking at the text before her, considering the history and the context, looking at the facts of the case, that's something that every judge should follow. And, you'd probably have a conservative justice saying exactly the same thing.
Have a couple up here, Megan, too.
Since public opinion is not always so easily, certainly not so accurately measured, do you have opinions, let alone evidence, that justices on the Supreme Court and their decisions reflect at least their perception of public opinion, as opposed to their political instincts, as opposed to their DNA?
I think some decisions do more so than others, but I think my sense of all 9 of the sitting Supreme Court justices is they are absolutely prepared to both sign on to and even write a decision that they know will be opposed by a significant number or percentage of the public. In fact, that is in some ways the essence of their job. And when the Supreme Court wrote unanimously in Brown v. Board of Education that it was time to end the horrific and immoral doctrine of separate but equal, that was not a widely popular decision, and they had the courage to do it anyway. I'm not saying that this is the same court now as it was in whatever that was, 1958, but I believe that the members of this court still have the courage to issue decisions that they perceive to be correct, but that they know will be unpopular.
And we had a quotation from Justice Breyer we didn't look at, but he said, easy things don't come to the Supreme Court. Only really hard things come. And so it's not, they're complicated, and they're trying to harmonize the lower courts, and there's a lot going on. It's not just your hunch on what is just.
We have a question from the online audience, and I would invite each of you to try to keep your answer under a minute on this one. All 3 of you are parents. The question is about young people and their relationship to their rights and obligations as citizens and community members. And the question is, what role does civics education play in the next generation of Americans?
I'll just yield to you two.
Yeah, I love that question. Thank you so much. And my 6-year-old is here with me tonight, actually. And I think that civics and an understanding of the fact that each generation needs to commit to our American democracy and making real the promises in our Constitution of equality and justice is essential if we want to continue as a thriving, egalitarian, inclusive democracy.
My experience homeschooling my kids, I talk to them about Supreme Court cases, both pending and ones that have been decided. And they are so fat. They would much rather do that than long division.
Same, that's why I'm a lawyer.
They light up, they thrive on it. So I think there's an interest, and if a parent or a teacher can find a way to present the questions and the material in a way that connects with the concerns that kids have, there's a real thirst in my perception. It's not just my own kids. I interact with high school students and others. So I agree, vitally important and perhaps easier than you may think.
Yeah.
Beautiful. Question here.
We haven't talked about the use of legitimate force. Every member of the U.S. military swears an oath to defend the Constitution, not the president, even though the president is his commander-in-chief. This has been emphasized time and time again over my time in the military. Now, is there a situation where the Chief Justice of the Supreme Court could go to the chairman of the Joint Chiefs and say, the president is destroying the Constitution. Do your duty, remove him from office, and call for new elections?
No.
Yeah, I think, I mean, first of all, no, also. And Chief Justice Roberts would like, he would have to be like invaded by an alien to do something like that. But, I do think your point is a very good one about the individuals swearing an oath to defend the Constitution and, how those individuals act when they are given what could be seen as an unconstitutional order. And I think, we are still going to see that, going forward.
My best friend is a West Point graduate, served honorably as an infantry officer and 25 years as a lawyer for the CIA. And I know from him that every member of the military has a duty to resist and not obey an unlawful order. You might not think that's true, but they do. And I hope that our soldiers keep that oath and that duty in mind should it arise in the next few years, as I think it may.
My question is about the kind of mess that I see the law becoming over the next 4 years with just orders from the Supreme Court without judicial reasoning. And I wonder if after 3 or 4 years of this, whether or not you'll even know what the law is for everybody to follow. Because I think that's creating a lot of the problem right now. With like even this with the judges being sued, that standing order of the Maryland court, was extraordinary, and so this becomes extraordinary, and pretty soon nobody knows what the law is. If you know what my question.
That's a fantastic question, and I would say that I share a concern. My concern is that, as we've discussed many times, the judicial branch is the only one without real power. They don't have the power of the purse. They don't have the power of the sword. What they have is the power of reason and the ability to articulate the rationale for a particular decision, such that even if you disagree with it, you can at least look at the rationale and decide whether you find it persuasive or not. I think Elizabeth and I have both seen cases where we disagree with the result, but we acknowledge the integrity of the reasoning, even while we disagree with it. I've seen other cases where I disagree with the result and I don't see any integrity in the reasoning, but let's put that aside. I have a concern that the faster the courts are forced to make these decisions, the less persuasive will be their explanation for their decisions. And I think it very well could lead to a further undermining in public confidence in the courts. And I really thank you for that question. It's a very perceptive and important question.
Yes, exactly. And that question is really gesturing at what is often called the shadow docket.
Yep.
And as suggested by the name, it's not a good thing. Like the last thing we want is our, justice being administered in the shadows.
Well, tell them what it mechanically what.
Yes. So generally, the way cases are normally heard by the court is, certiorari is granted. That means that review is granted, and there's already been a petition and an opposition and a response on the certiorari stage. After the Supreme Court grants review, then there are the parties' briefs. There are, depending on the case, a lot of friend of the court amicus briefs.
They really only need 2. But.
Yeah, I know. They just need ours. And then there's oral argument, which now, this is one good thing that the COVID pandemic brought. Now we can listen to the audio. Before you weren't allowed. We didn't unless you were actually in the court. It's very hard to get a seat in the court. You couldn't hear. So we can hear the audio of the oral arguments, and then they have months, depending on what part of the term the case was argued in, they have months to go back and forth, circulate drafts, come up with reasoning, come to the final vote, and then they issued the opinion for all of us to read and cheer or boo, as the case may be. And we see the majority opinion, we might see concurrences, which agree with the result but have different reasoning or want to emphasize a certain point, and the dissents. With the shadow docket, the cases get there much more quickly, not through the regular process. There generally is not time for extensive briefing, although a lot of us are trying to get there quick enough to file our briefs, but sometimes it just isn't possible. And there generally is not oral argument. And a lot of the decisions that come out, especially in the majorities, so they don't have to specify the vote count. A lot of times we only know how it went by looking at the dissents, but that doesn't necessarily, tell us a lot about how the court came up with its decision. And in a lot of cases, there is not extensive reasoning. And these can be incredibly important cases. And the shadow docket is something that has become, I think, probably the Obama administration, and it's only ramped up since then with the court. And it is very concerning. And this is getting back to the point about, do they care about public opinion? There was a lot of public criticism of the use of the shadow docket in recent years. And I personally think that led to them in one of the abortion cases, the one out of Texas, even though it was technically on the shadow docket, they still held oral argument, which is unusual for a shadow docket case. And I do think it was because they were sensitive to that very powerful public criticism. Yes, absolutely. And, with the Trump administration, I think in particular, because there are so many unprecedented, extraordinary, and in my opinion, unconstitutional actions, it's definitely stressing
We just
that
got
docket.
a few minutes left here.
I'll make it quick. Thank you all. On the question of enforceability and on the question of reform, they both kind of come down to an assumption that the other institutions of our government work, particularly the Senate, but not only the Senate. The U.S. Marshals come into play there. What is a reasonable expectation of reform and enforcement if there continues to be the degradation of the other institutions? And can any of this happen without election reform?
I don't know. I don't know that that's a legal question. I think it's more of a political question. I'm a constitutional lawyer, not a political scientist. I'm very concerned. I'm deeply concerned with what we're going to hand off to our kids and our grandkids if we're still around for grandkids. So I don't know. For me, I'll just say what my biggest concern is. I believe that maybe the biggest villain here is Congress for abdicating its constitutional responsibilities. And I hold the Senate particularly culpable here because I think the president seems to have come to the conclusion that he is unimpeachable at this point. And I think he may well be right. And I think we have never been in a more dangerous time with a president of this disposition to perceive, perhaps correctly, that he will not be impeached no matter what he does. That is an incredibly perilous place to be.
So, James, are we out of time? We got one more. Sorry for those we haven't gotten to.
Do you think the 6-3 majority on the court might be afraid to rule against Trump because they know he would disobey their ruling?
I mean, I think as we got to a little bit earlier, I do think they're going to be mindful of that fact. They're obviously savvy, smart people who exist in the world. I hope that they have the courage to stand up and take the constitutional role that is given to them. And I, as a Supreme Court litigator, I have to have that hope. That's what I give my days to. So I hope they will. I do think they will be very strategic in getting to that battle and trying to avoid it if they can. Chief Justice Roberts is a very savvy, he was a brilliant litigator. He's, I disagree a lot with his decisions, but he is very good at crafting judicial decisions. and sometimes getting places that you don't even realize he's gotten. He's kind of the Marbury. He could have written Marbury,
That's right. That's right.
And I just want to make sure that I get to something that you asked about court reform and its possibility in election reform. In a lot of ways, that's up to all y'all. Are you going to vote for people who want court reform?
Mm-hmm.
Are you going to ask them about court reform? This is not often part of, the conversation. And so in a lot of ways, talking more about the court is something that voters have to demand.
So as we close here, I just wanted to do a couple of things. First of all, to thank all of you. I think this has been one of the most important conversations we've had here. I'm thrilled by our presenters, and thank you for briefly addressing very complex issues, that each one of which could have been a week-long seminar. Judge Luttig set the bar for real pessimism. Just as we close, very quickly, Clark, are you more optimistic than he is, or are you with him?
Well, I don't know that it's possible to be less optimistic. If I'm not in the same room with him, I'm adjacent.
Elizabeth?
I am deeply, deeply concerned about this moment. I think we are in a constitutional crisis. But as a student of history and as someone who follows the arc of progress that our constitutional journey has taken this country on, I know that we can do hard things. I know that we can, if we choose. I think of Frederick Douglass, who is kind of my guiding light when it comes to constitutional interpretation. The Constitution as it was written, and I think the same could be true today, can be used as a tool of oppression, or it can be used as a tool of liberation. And a lot of that is in our hands. And we have chosen at key points to use it as a tool of freedom and liberation. And I hope that this moment is not just, a pendulum swinging. I hope it's a boomerang moment where we are being pulled so far back into the Judge Luttig version of where we are. We're being pulled so far back that when we let go from that, we will be boomeranged into a brighter future and making real the promises in our Constitution.
So, oh yes, the triumph of hope. Let me pull you one last time very quickly. You have to choose one of three things, and don't yet. One is that we're done. We're toast. This is it. It's over. And Judge Luttig was almost there. Number two is we're in a really, 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 really serious crisis, and it's going to take some very extraordinary things to get us out of it. And number three is, we lurch from chaos to chaos, and we always survive. How many we're toast? How many are like the severity of this thing, but and how many are like, no, it's going to be fine.
I'm in the boomerang.
All right. Thank you all.
Ladies and gentlemen, Clay Jenkinson, Elizabeth Wydra, Clark Neely, our special gratitude to Judge J. Michael Luttig,